star now. You will now be placed into conference. To mute your line, press star 6. To unmute, press pound 6.
This is Patty McCarthy Metcalf, and I am the Executive Director of Faces and Voices of Recovery, and I welcome all of you to this event today. We're really pleased to have the Legal Action Center here with us to talk about this very important topic. And as you know, Faces and Voices, as the a national advocacy organization for addiction recovery, is very, very focused on the rights of individuals with many pathways to recovery, but today we're focusing on medication-assisted treatment and recovery and the legal issues surrounding that and how to advocate for individuals in their recovery. So I'm really thrilled that there's so much of a response today for this information, and we encourage you to stay involved with Faces and Voices and ask questions and join our mailing list and come out on March 1st for our Recovery Day on Capitol Hill, and stay tuned for our next our third Thursday's webinar, which of course will be March 16th, 4 weeks from today. So I would like to just a little bit of the logistics of the room. Wanted to tell you that the slide presentation that you see on your screen right now is available as a PDF. It's in the files box on the bottom left. It says Matt's Toolkit, LAC. If you highlight that with your mouse there, you can click on it and click Upload File. So you could open that up and have it with you for future reference. I'm also going to be adding a couple web links in the bottom left corner of the room, and you'll be able to find the MAT Toolkit on the Legal Action Center website by going to that link, and you can follow along there as well. So I'll do that in a moment. So during the presentation with Sally, we welcome you to chat, say where you're from, say hello, comment on any of what you hear. But what we'd really like is some interactive, question and answer with Sally as a national expert on this topic. And so please feel free to ask your questions in the Q&A box, and you will be able to, and we'll respond to those. And I'll be moderating those questions and reading them to Sally so that she can respond as we go along. So I guess without any more information, I just wanted to pass it on to Sally Friedman, who's going to introduce herself and her background with the Legal Action Center. Welcome, Sally.
Thank you, Patty, and hello everyone out there in webinar land. My name is Sally Friedman, and I am the Legal Director at the Legal Action Center. I was going to have a co-presenter today, but Melissa Trent is out sick, so I will be chugging along myself. And I want to just tell you a bit about the Legal Action Center in case you don't know us. We are a nonprofit law and policy organization, and we work on anti-discrimination and privacy issues related to substance use disorders, criminal records, and HIV/AIDS, and we do that through providing training and technical assistance, as well as litigation, legal services, and policy advocacy. Throughout the webinar, a number of places I'll say, call us. And so here's the one place we list our phone number. Also, if you want to stay current with Legal Action Center and all the news we're getting out there about these issues, including today's topic, I suggest you go on our website and subscribe to get news alerts, and also follow us on social media. What I'm going to cover today, there's two number ones here, but there are strategies, first strategies about how you can advocate for specific patients' right to a medication-assisted treatment when different people in the criminal justice system or child welfare system tell them that they cannot have access to MAT. And I'm not talking so much about prisons and jails as much as community-based settings like probation and drug treatment court or parole. And second, I'm going to focus on the Legal Action Center's recently released report about recommended strategies for medication-assisted treatment in drug courts and how you can use that report to work with courts and other criminal justice agencies to incorporate MAT. So the first part is more individual case advocacy, and the second is more kind of broader education to bring folks along. Everything I'm going to talk about today is in our new MAT Advocacy Toolkit, which you can, there's live links throughout this PowerPoint, so if you can click on these links or just go to lac.org/mat.advocacy, you will see all components. And for today's presentation, I'm going to assume that everybody on this webinar is already familiar with the basics of what MAT is and why it's a critical treatment for opioid addiction. I'm going to focus on other issues that assume that knowledge. So in the MAT Advocacy Toolkit, there's about 8 or 9 parts of it, but the parts that I'll be talking about most today are these parts. The first document is for individuals about how to advocate for your recovery when you're ordered off addiction medication. There's a sample letter for treatment providers to use when they're writing letters on behalf of their clients. There's a guide for attorneys, the drug court report I just mentioned, and then a report by the Legal Action Center about why denying access to MAT can be illegal. And I'll talk about these more throughout the presentation. And again, this is probably the second of many, many references you'll see to the link for the MAT Advocacy Toolkit. So we wanted to pause just to get a sense of who's here today. Patty's going to conduct the poll. You're going to have access to a little poll where you're going to be able to say whether you are a MAT provider or an interested person or advocate, a government agency, or are you with a legal organization or other. So Patty, do we have the poll?
Sally, we're going to have to come back to that poll. I didn't
okay.
push it into
Technical
the room,
problem.
but I will do that in
okay.
a few minutes. Okay.
Okay. All right. In a few minutes, we'll find out who you are. Starting with part 1, advocating for patients who are forced off MAT. And I should say it's really not only patients who are forced off MAT, it may be also patients who are appropriate for MAT, but they're not allowed to enroll. So before I get into some of the brass tacks about the advocacy, I thought I should provide some legal background, which is there are a very small number of states in the country that have recently passed laws that limit the ability of criminal justice agencies to prohibit the use of MAT. So the only 3 that we know about so far are New York, New Jersey, and Illinois. So if you are in one of those states, you should become familiar with those laws. And they are fairly narrowly written and, as I said, only in 3 states, but good to know about. In terms of MAT in jails and prisons, there are some cases that say that not providing people with supervised medical treatment while they're withdrawing from opioids, whether illicit or from a doctor, can be unconstitutional. But there is nothing in case law about the right to ongoing MAT treatment in a jail or prison. And another kind of piece of legal framework I wanted to offer was that some of you may know that about 1.5 years ago, both SAMHSA and the Department of Justice started requiring federally funded drug courts to allow MAT. And that, I think, shook up the world a little bit. But it's been a bit unclear what you can do if your local federally funded drug court is not allowing MAT. Like, who exactly do you complain to? But again, it's something worth knowing, and as you'll see throughout the program, we do offer our own help in these cases, and so you can always call us and we can figure out what to do. So another important kind of part of the legal landscape is that we believe that denying access to MAT can violate anti-discrimination laws. And I'm sure you're all familiar in general with the Americans with Disabilities Act, which prohibits state and local governments, including courts, from discriminating against people with disabilities. And so the purpose of the ADA is to require fair treatment of people with disabilities and treating people with disabilities based on what each individual can and cannot do, and not treating people based on outmoded generalizations and assumptions about what they can do. So this law requires that when you make decisions that affect people with disabilities, you do it based on objective, individualized evidence, not stereotypes and myths. So when we apply that to the MAT context, we certainly conclude that courts and probation departments and parole agencies and child welfare agencies that prohibit people with opioid addiction from accessing MAT based on these kind of broad assumptions about the validity or lack thereof of MAT without doing any kind of legitimate individualized evaluation, that they violate the Americans with Disabilities Act, because people with opiate addiction are considered to have a disability. And we spell out our theory about this in detail in the report, Legality of Denying Access to Medication-Assisted Treatment in the Criminal Justice System, which is in the toolkit. So I'm not going to spend more time on kind of parsing out our legal theory, but a lot of the advocacy that I'm going to talk about is based on the assumption that these practices violate the ADA. So I want to at least let you know where you can read about that in more depth. But in order for anyone to ever successfully be able to make an ADA claim, they're going to need to gather and present evidence about why in their particular case MAT is appropriate for them. And then they're going to, as well as information about MAT generally. So a lot of our advocacy toolkit talks about what's the best way to do that? What's the best way to gather and present evidence that MAT is appropriate for a particular individual? So when your clients or people in your community, your loved ones, whomever, you yourself maybe, are prohibited access to MAT, we suggest that you educate the courts and other decision makers, provide resources to patients and their advocates, and help people find an attorney who is willing to advocate for their access to MAT and connect that attorney to us, the Legal Action Center. I'm going to go back for a second. So we found that a lot of attorneys aren't familiar with the issue about MAT, and so that's why we note that you need to find an attorney who's willing to advocate for MAT, because they're not all that way. And I'm going to go into each of these in much more detail. So starting with education, the very first thing that needs to get done if someone is being denied access to MAT is to gather the objective evidence about why MAT is clinically appropriate for that person. And to make it easier for providers to do that and to make sure that they write the best possible letter, we've created a sample letter that's in the MAT Advocacy Toolkit for treatment providers to use. And it's a template that you can fill in. It's available in Word format. And the reason why we have done this is because our clients, we get calls from all over the country when people are being told they have to get off their MAT medication or they can't enroll in the first place. And well-meaning providers often will write a letter that we consider to be too short on detail, and that will not convince the decision maker, and that will not make a sufficient record in the court for any kind of appeal to challenge the decision to deprive that individual of MAT. So, and we've talked to a lot of people in the criminal justice and child welfare system who are not friendly toward the idea of MAT, and we have a sense of what we think needs to go in these letters in order to convince them. Not that everyone is convincible, but at least to have the best shot at convincing people. And when you write a letter, when a provider writes a letter on behalf of a patient in support of MAT, I think it's important to assume that the reader knows absolutely nothing about MAT. The reader may have assumptions, and probably does, about MAT, and they're probably not very favorable perceptions, but the reader generally really won't have the facts. The reader also may think that the MAT provider is really motivated to keep the person on MAT because it generates money for the program, and that the person has no incentive, the program has no incentive to get the person off, and that's why they're recommending that the individual stay on their MAT medication. So we recommend that the letter include the credentials of the person writing it, what the diagnosis is, and the treatment, and including supportive services. A lot of judges and criminal justice officials we've spoken to think that people get their medication and then that's it, that they don't get any supportive services. So it's important to include in letters whether the person is getting counseling and any other supportive services. Also, what's the clinical criteria for MAT? Why did you determine that this person is appropriate for MAT? And what's been their history of treatment and their progress in treatment, and then we talk about some of the just general basic scientific evidence in support of MAT, and the risks of forced taper, especially if it's a pregnant. I shouldn't say especially, but including if you have if the person who's being ordered off MAT is pregnant, it's important to point out the dangers there, and also to explain how the program evaluates periodically whether to continue this person on MAT. Because again, the court or probation may think that, well, of course you're going to keep the person on MAT. Why not? You're making money off of it. So it's important to show actually we do a periodic reassessment, for continued to see whether the person's appropriate to stay on that. And then also explain the dose. How did you decide whether the dose? Because there's also a lot, and I'll talk about this more later, there's a lot of misunderstanding about how dose is determined for methadone and Suboxone, and a lot of courts will think that someone's on a dose that appears too high, even though they have absolutely no medical basis for thinking that. And to the extent that any other concerns have been voiced by the court, to include those in the letter. And if the patient has an attorney and agrees that this is a good strategy, providers should offer to testify, and I should say, and if the court allows it. And in-person testimony can cover the issues in the letter, but in greater depth. And again, this will form the record, so that if the court continues to deny access to MAT, but the patient's attorney appeals that decision, then there'll at least be evidence in the record about why MAT was appropriate. So after the treatment provider writes that fantastic letter, the treatment provider should also share with patients this Advocating for Your Recovery publication. There's a picture of it on your screen. And in this document, we go through step-by-step what people can do when they're being forced off their medication. We have another small publication called The Attorney's Guide, Addiction, Medication, and Your Client. And we created this, and it's very short on purpose, because we found that when people contacted us and they were being forced off MAT, and we would say, well, have your attorney call us, we never hear from the attorney. And then they would often say, well, my attorney thinks I should just get off my Suboxone or get off my buprenorphine. Doesn't think there's a problem with that. And so we realized we really need to give something that they could hand to their attorney to kind of quickly educate them about some of the issues. So this is about a 2-3 page publication for lawyers. And then, of course, there's a lot of parties to educate in this circle here. So we have other materials that can be useful when you're educating the decision makers, the judges, the probation officers. It could be child welfare officials, and parole, it could be the DA, the prosecutor. So we created this myth and fact sheet, which is available in the toolkit, of course, like everything else I'm talking about today, and which contains some of the most common myths that people tend to hold about MAT and that motivate people to prohibit it. And I'm not going to go over them all today, but I thought I would point out some of the most common myths that I'm sure you've all heard and how we suggest countering them, although other folks may have better ways. So I think the most common myth about MAT is that it substitutes one addiction for another. And so the fact sheet explains the difference between physical dependence that's created by methadone and buprenorphine, but not by injectable naltrexone, that's different from addiction. And that when properly prescribed and taken, the MAT medications address the cravings and the physical responses so people can actually focus on counseling and do the work they need to do to enter recovery. And so that it's not just take the pill or take the strip or the dose of methadone or the injection of Vivitrol, and that's the entirety of the treatment. You're doing that plus other kinds of counseling. And I think a lot of folks don't understand that, and that these medications are similar to medications taken daily to treat other chronic conditions. Another common myth we come across is that if you're going to be on MAT at all, you better be on a low dose. Now, again, this only applies with methadone and buprenorphine because the dose for injectable naltrexone is as a standard dose. But with our clients who've been on methadone and buprenorphine, we've seen judges arbitrarily lower their dose, and which I'm sure everyone on the phone here or on the webinar understands that that's a really bad idea. So it's important to explain to the decision maker that dosage decisions are individualized clinical determinations and that there's no one-size-fits-all dose. And again, that's something that can be done in the treatment provider letter or whoever is engaging in this education. I think this is one of the most important points to get across. And the judges are not qualified to make these medical decisions, just as a judge wouldn't tell someone how much of their heart medication to take. Another big myth is that if you're going to be on MAT, it's got to be for a short term only. And we've seen different variations of this. Someone may think a week is enough. Someone may think 3 months is enough. But there's this kind of idea out there that it's time to get off. And so so we provide information in the myth and fact sheet and elsewhere in our materials about how MAT is more effective in the longer term. And for example, that SAMHSA recommends 3 different phases of MAT with stabilization, a middle phase, and ongoing rehabilitation. But all of this goes to the issue of that actually longer term MAT results in less illicit drug use. And so we provide you with information that you can use when you're conducting this education. And in my slides and in the myth and fact sheet, we have all kinds of citations to back up everything we say with scientific research. The final myth that I'm just going to go over right now is the one that, actually maybe it's second to final, that forcing someone to taper off is a good thing. Right? That's why it's often done, because the judge who's ordering it thinks they're helping the person. So it's the advocate's job to explain why forced taper is actually harmful and potentially fatal. And there are studies that show that forced taper increases the risk of relapse and death. And as I'm sure you all know, that especially when someone's coming out of incarceration and their tolerance is down, one episode of misuse can result in life-threatening or deadly overdose. And so SAMHSA recommends that no one ever be coerced to taper. And so this is, again, one of the main driving motivations, I think, behind a lot of courts who they don't allow people to be on MAT is they think they're doing them a favor. And so this is some scientific evidence to show that is not the case. So we also have lots of resources to share with the decision makers in the criminal justice or child welfare system. And they include our book, Report on Drug Courts, Recommended Strategies, which I'll be talking about in part 2. And we also have drafted a sample letter that people can use if they're writing to courts or any other agency who's forcing someone off MAT. And the letter provides lots of arguments about why MAT is effective and forcing people off is dangerous, and it also violates anti-discrimination laws. And so that sample letter can be shared with people's lawyers. So, or, advocates can use it, although courts may not care if someone writes them a letter if they're not actually representing the client. But anyway, we provide all the arguments in there so that other people don't have to reinvent the wheel. And we really want attorneys to contact us. The Legal Action Center has been very interested in quite a while in developing a test case to challenge the forced, tapering and denied access to MAT in the criminal justice system. And also in the child welfare system, we've been getting more and more calls lately from people who are being forced off MAT by courts as a condition of having custody of their children. And nobody has really, no court has decided these issues yet. There was one case brought in Kentucky a couple years ago, but it was dismissed on procedural grounds. So no court has actually entertained this issue. And we've been looking for the right case, and our major challenge has been the lack of defense counsel on the ground to work with us. So the people who call us often don't have a lawyer, and if they do have a lawyer, the lawyer is often, as I mentioned earlier, hostile to MAT also. So we're working on educating the defense bar, but that's something that we can ask you for help with. So we really want to, if there's any lawyer representing an individual who's being denied access to MAT, we want to talk to them. Oh, I'm hearing some background noise, Patty. I don't know if someone's unmuted.
I hear that too. If you could all mute your phones, that would be very helpful. Thank you.
So what we'd like to know about also is if in your area you're aware of any courts, government agencies that are denying access to MAT, we'd like to know about it. And so we have an online form that's on it's in our MAT Advocacy Toolkit. Our MAT Advocacy Toolkit is essentially one page on our website with all these different reports and advocacy sheets I've been talking about, but there's also a link to an online form that people can fill out and put in information about what's going on in their area, and that has been a great way for us to gather data about what's happening around the country. And we're, as far as I know, the only people who are gathering this information, and so even if we can't successfully advocate for someone in a particular case, we're finding that this information is very useful in our overall advocacy. And so we urge you to, circulate that widely and have folks fill out those forms. And again, if you know your area's public defenders, connect them to us and try to educate them. So, we can use your help in reaching out to local public defenders and educating them. If anyone participating in this webinar is a treatment provider who's willing to serve as an expert for free in a case, even remotely, via video or phone, or to write an affidavit, let us know. And also just spread our resources, far and wide. And Melissa Trent, who the person who's going to deliver the webinar with me today, is working on this issue here, and so you can contact her at the email address on your screen, or again, just fill out the form. The states we're particularly interested in bringing a legal challenge are listed on your screen, and we've chosen these states for a variety of reasons, having to do with kind of frequency of complaints we get from them, but also areas where we think the courts might be more open to these arguments. And so, but if we'd speak to any attorney in any state. We've also recently been successful engaging the Department of Justice on this issue, and we're hoping that the Department of Justice will continue to be interested in this issue under the new leadership there. And but we need to get complaints that we can give to them. And so, and the reason the Department of Justice would be interested in this issue is because they do enforce the Americans with Disabilities Act, and as everyone on this webinar knows, the opioid epidemic is a huge issue nationally and politically, and so there is interest in getting the federal government involved in stopping this discriminatory blocking of access to care. And so, people can contact their local U.S. attorney's offices if they have a civil division, because these are civil rights issues. This is not a criminal. I mean, the U.S. attorney's office wouldn't be coming in on a criminal angle. They'd be coming in as a civil rights issue, because denial of access to MAT violates the ADA. But we would suggest talking to us first before you approach DOJ, and maybe that we do it instead. So because we're cultivating our connections, but if you have connections with your local U.S. Attorney's Office, civil rights folks, you should definitely let us know, and we could talk about how to interest them in the issue. Because they can do outreach and education to criminal justice agencies and courts. They can issue letters that express their kind of opinion about that this is discriminatory, and they can bring enforcement actions. They have a whole number of things they can do to move this issue forward. And to date, DOJ has not spoken out officially on this issue, and we think that it would really help a lot if they did. So that's why we're working on that. Patty, if we're ready for our second poll, I thought we would ask folks in the room, as it were, the virtual room here, if you've done advocacy on this issue, and have you been successful, not successful, or have you not tried? So I see the poll on the screen. Folks can vote. I'm going to wait another minute. I see only 8 people have voted so far, and we have a lot more participating. And I am curious to know the result here. Well, I'm watching the votes, and the trend, even though more people are voting, the voting pattern is somewhat consistent. It seems like the majority of folks have not yet tried to advocate on this issue, and I don't know, maybe 30-something% have tried to advocate but not succeeded, and an inspiring 16% have actually successfully advocated for a court or criminal justice or child welfare agency to allow MAT. Oh, it just shrunk to 11%. Okay, so I think it's pretty clear that most of you have not yet tried to advocate, so I'm glad you're on this webinar. Those of you who have had about twice the failure rate as a success rate, but that is no reason to give up, and hopefully the success rate will go up with the MAT Advocacy Toolkit and some of the things we're learning today. I should say that this is not an easy task to convince a reluctant criminal justice agencies, courts, child welfare officials to allow MAT. There are some very entrenched beliefs that stand in the way, and but things are changing. Things are definitely changing due to a lot of factors, including the opioid epidemic and some of the DOJ and SAMHSA mandates, and there's been a lot of push to expand access to MAT. So even if people have not succeeded in the past, I would urge you to keep trying. I think this is a time that I want to stop for questions, although I also wouldn't mind doing the poll now, Patty. Maybe you can bring back the first poll so we know who's participating today. So can you just let us know whether you're a MAT provider, someone who's just interested, work for a government agency, etc. We'll give it about 10 seconds. Okay, well, again, we don't seem to have full participation here, but of those who have responded, looks like most of you, about half of you, are from the government, and a quarter are MAT providers, a quarter are interested people, and some others. Okay, Patty, you can close the poll, and we'll move on. Ooh, someone's from a legal organization, I see. That's good news. Okay, so let's take some questions if we have any. Any yet? Any questions?
Sally, I haven't seen any questions. I think they're all taking it in right now and maybe downloading the files. But feel free, everyone, to just type your question or comment or any observations you've made in your communities into the Q&A box, and I'm happy to share them with Sally. So we can go ahead and move on, because I don't see any coming in, but I will let you know.
Okay. You know, and at the end of the program, which, you know, when people don't have a lot of questions, we tend to move more quickly, so I think we probably are going to finish a little early. And if people who have successfully advocated for MAT want to talk, we can kind of unmute and people can actually talk because it's not such a huge crowd today. So think about that. Okay, so now we're at part 2, which is how to use the Legal Action Center's report about recommended strategies for MAT and drug courts to advance your advocacy. And the first thing I want to say is even though the report is about strategies in drug treatment courts, it really is useful far beyond that. It's useful in any court setting or even like probation or parole setting because it addresses a lot of the same concerns that drug treatment courts have about MAT are concerns that other courts and criminal justice agencies have about MAT. So definitely use the report even if you're not advocating in a drug court setting. So we wrote this report last year because clearly the opioid epidemic was resulting in a lot more people with opioid addiction coming into drug court or wanting access to drug court. And as mentioned earlier, SAMHSA and DOJ had begun mandating that drug courts allow MAT if they were federally funded. There were some state laws, and yet under results of a 2014 survey showed that about half of the drug courts in the U.S. that were surveyed did not allow any form of medication-assisted treatment. So, here you have half the courts in the country not allowing it, and yet federal government is telling you you have to, and of course people are dying of opioid-related overdoses left and right, and so the same thing was going on in the child welfare system. People are losing parental rights permanently, losing visitation and custody rights of their children, and so we thought we need to do something. In addition, we had participated in some trainings of drug courts in New York State in 2014, and we were training people about MAT and about why it was discriminatory to deny access to MAT, but a lot of the people in the room who represented all parts of drug courts had some really kind of practical questions about how you do it. How do you monitor all these people? Does it cost money? We're tiny, our staff is tiny, we don't have lots of extra time. How do I as a judge even know whether MAT is appropriate? And what about the DA? They're opposed. And who's going to pay? And who's going to pay later if the drug court participants get jobs and they no longer are eligible for Medicaid? Who's going to pay for their MAT then? So we heard all these questions, and we realized there was actually no resource that showed how courts that do allow MAT do it. How do they address all these issues? So we decided we were going to write that report. So we worked with the New York Office of Court Administration and the Center for Court Innovation, and we identified 10 courts in New York that permitted every form of MAT. That was a requirement for us to even talk to them, is that they had to permit all 3 FDA-approved MAT medications without interfering with the clinical judgment. And we looked for courts in a variety of areas that covered what we thought were like all types of demographics, geography, and size in the state. Courts that had a lot of MAT available, courts that had very little MAT available. In the counties. We spoke to all 10 of them, and then we decided which 3 we were going to do in-depth profiles in a way that would represent very diverse kinds of areas. And we were looking for courts that would represent courts across the whole country. So courts in rural areas, urban areas, big, small. Courts where there was no methadone available, courts where there was methadone available, so courts where there was Vivitrol available, courts where there wasn't. So we tried to just run the gamut. And we spoke to them in depth about their challenges and the strategies they used to overcome the challenges associated with having participants on MAT. And after speaking to these 3 courts in depth and the other 7 courts in a bit less depth, we visited the courts as well. We kind of analyzed the results, and we gleaned that there were about 9 common threads that ran through all these court programs. And I'm going to go through them all. And so the first one is that counseling and other services, in addition to the medication, was essential. So all 10 programs required that all participants receive counseling and wraparound services, whether they were on MAT or not, and that the counseling would decrease as the patient progressed and eventually completed it. And then they would stay on the medication, but they would have finished the counseling component. And this addresses probably one of the most common concerns about MAT is that it's just medication and nothing else. And that just is false in these courts. The second component we found, which also addresses one of the major concerns we kept hearing about, was the courts were very selective about who their participants got their MAT from and which doctors prescribed Suboxone, or if they hadn't Vivitrol available, did that. So they basically all required an assessment of the participant by a designated licensed treatment program. And that had to be a treatment program that used all forms of evidence-based treatment. And often it was on a list. The court would hand the person and say, you can get assessed at this location, and then you could get treatment at these different options. And they would, the exception would be if a licensed program in the area, let's say, reached its buprenorphine cap, which at the time we did the report was 100, now it's 275, so this probably is not as big of an issue. They would allow the participants to receive their buprenorphine from a private doctor that the court has approved, and then get counseling from a licensed program. So again, this may be less of an issue now, but again, they were very particular about who provided treatment to their participants. And the court, not the participant, chose the MAT provider, as they did for all treatment. And then if they found that they were not getting what if they found certain treatment providers unsatisfactory, they would discontinue use of them. And so the courts basically had certain requirements for treatment providers that they were going to make referrals to. And I think that for those of you who are treatment providers or who work in government agencies that oversee treatment providers or just work on this issue, it's important to see what it is that the courts are looking for in treatment providers that are providing MAT to their participants, and probably just to providing any kind of treatment. First and foremost, reliable communication. So the court needs to be able to get consistent and accurate reports from the treatment provider. Second, they want to make sure the provider is monitoring the patient carefully and following through. Third, that they're getting they have a quality therapeutic relationship. And for those participants who are getting their MAT medication from an office-based physician, they had to ensure that they were using appropriate clinical standards. For example, that they actually examined the patient and did urine testing and didn't just kind of prescribe without ever seeing the patient and not doing monitoring. And almost all the courts we spoke to, I think all of them, did not allow participants to go to what are known as cash-only doctors. And I just want to emphasize that a lot of the reluctance I've heard from courts that didn't allow MAT was that they had concerns that people would be getting their buprenorphine in particular from unscrupulous doctors. But, kind of the retort is, well, then don't allow them to go to those doctors. Find doctors that, have appropriate that follow appropriate clinical standards and allow them to only go there. Third was that the courts developed strong relationships with their treatment programs and required regular communication. I mentioned the communication thing before, and I'll keep coming back to it. The courts all thought that having a trusting relationship that involved communication with a program was a fundamental baseline. And if the programs didn't communicate sufficiently, the courts discontinued using them. Now, of course, if you're a court in an area that has only one treatment program, you can't really you can't just discontinue them because then there's nobody else. But where there were options, the courts were very clear about their requirements and tried to work on those relationships. And they all thought that working with licensed programs was the better option. And so if a lot of the courts we spoke to did not have a lot of availability of methadone or injectable naltrexone. It was really mainly buprenorphine that was available in those areas. Not all of them, but most of them. And so, but they really, again, resisted involving private doctors unless they had no choice, and saw licensed programs as kind of more reliable communicators and better at doing monitoring. And there's still somebody out there on the phone who's not muted, so can you check your mute button, please? A fourth component we found is that, the screening and assessment had to consider all clinically appropriate forms of treatment. So you couldn't send a participant to an assessment that ruled out MAT for all people. So the court did the initial screening, but then they would refer to programs on the list that would open to all appropriate clinical modalities, including MAT. Fifth is that the judges relied heavily on the clinical judgment of the treatment providers and the court's own clinical staff, and believed that decision-making should be evidence-based and should be made by clinicians, not by them. So these judges all understood that they were not doctors. It so happens they weren't. Maybe some judges are, but these were not, and I don't think most are. So these judges understood that they were not clinicians, and the decision-making about appropriate treatment should be left to the clinician. Wait, did I just go from 5 to 7? Ooh, I think I misnumbered that. Okay, so all the courts also were very careful about how they monitored for illicit use of MAT medication. And they had different ways of doing it. And so, and in fact, I had heard from many courts prior to doing this report that concerns about how they would monitor MAT medication was one of the greatest obstacles. I think they were most concerned about buprenorphine because of the way it's prescribed, where people can get 30 strips at a time, and it's commonly sold on the black market. And so some judges and probation departments just felt that how can we allow people to be on buprenorphine when it's just so difficult to monitor? So we were really interested to know from the courts that were allowing people to be on all forms of MAT, well, how are they monitoring it? And so we found out that they all were doing it fairly well. And they were doing it, this was a big surprise, they were doing it the exact same way they monitor for illicit use of any drug for any type of participant, with only a few modifications for their MAT participants. And the ways that they commonly do it, they all pretty much believe that injectable naltrexone was the easiest to monitor because doctors give a shot once a month and there's no street value. So, but in the courts we spoke to, there wasn't a lot of use of naltrexone because it wasn't that available, and at the time, which was a year or two ago, there wasn't as much insurance coverage for that, but that is changing. In terms of methadone, they generally found that was fairly easy to monitor because they didn't allow people to take it home, so they had to take it at the clinic. And they acknowledge that most of the methadone that's sold on the street is methadone that's prescribed for pain, not for addiction. So they weren't that concerned about monitoring the methadone. Of course they monitored it, but they didn't see a problem of kind of illicit use of it. They were all the most concerned about the diversion potential for buprenorphine, but they felt that they could keep it under control. And even though participants, when they came into the drug court at the beginning, almost all reported that they had used buprenorphine illicitly prior to coming into the drug court, the courts found that once they were actually enrolled in drug court and in a buprenorphine program, they were not using it illicitly. They were not buying it on the street because they were getting it from their doctor and it was working for them. And that it was actually the lack of access to legal buprenorphine that was resulting in the illicit use of buprenorphine. And that's a really important thing to explain in your advocacy. So I have found that courts and others get confused between those two things. They know there's a lot of illicit use of buprenorphine on the streets, and so they just assume that's what's going to happen if participants in their drug courts are in buprenorphine programs. So it's important to explain the difference between illicit use and what drives that and what goes on when someone's actually getting it legally. So they all also require urine testing, and they do it themselves, and they also have the programs do it, and they try to do it in an unpredictable way. And those courts that feel like the programs didn't do enough of it did more of it, and vice versa. They also do, some of them count pills and strips for buprenorphine, and they all also do behavioral observation. They expect the program to do it, And the drug court team did it too. So when someone comes in for their drug court appearances, are they speaking truthfully? How do they look? What are they behaving like? What do they hear from other participants? And they felt that the behavioral observations were as important as the other methods. They also communicate regularly with the treatment programs. Again, this is probably the third time I'm talking about communication because that's how important it is. They want to make sure programs are being honest and that when they send emails and make phone calls, they get a response. And and I say this because, at the Legal Action Center, we also specialize in the confidentiality of drug and alcohol treatment records, and we've spoken to many, many, many drug treatment programs about how to communicate with the criminal justice system. And so it was interesting for me to hear it from the other side about how communication is so important to the criminal justice agencies and that needs to be done in a kind of an honest, open way, obviously complying with the federal drug and alcohol confidentiality law, but they really need it in order to be sure that they're doing their jobs and that they're monitoring appropriately. And the amount of the communication depends on a number of factors. So when someone's earlier in treatment in the drug court, they are going to communicate more, and as that person approaches graduation, they don't need to communicate as often. But they want to make sure that that they swiftly address any lapses, and so another program is responsive. And they found that all the courts said that if they didn't get enough communication from the programs, then they would stop referring. So another component, needless to say, it's important that the MAT medications get paid for. So in all these courts, the participants had coverage through government, like Medicaid, or private insurance programs. And this varies from state to state. In New York, there's pretty good coverage, and more and more MAT medications are being covered. Because of various things, including, the Affordable Care Act and the parity laws. Let's hope that continues, that good coverage, or that growing coverage, I should say. So there were some courts that were concerned that if the participant started working, which is what they're supposed to do before they graduate, that they would lose their Medicaid, and then how would they pay for the MAT? In fact, I had heard from one drug court that didn't allow MAT that they thought, well, the person's not going to be able to pay for it later, so they might as well, so why get them on it when they can't pay for it later? So I asked the courts that I spoke to, well, so what do you do about that? And those that had encountered the problem said that they tried to help people find other payment options, and again, it's different in each state, but that no one really found that to be a major barrier. And so I think this is the final issue, is that the bottom line is that the MAT part of the drug court operation really wasn't all that different to the other parts of the drug court operation. So the courts didn't really do that much differently for MAT than they did for other participants. The main difference was getting everybody on the same page and overcoming a lot of the opposition, and then doing some potential tweaks in the urine testing. Subcourts tested all participants for MAT meds. Some didn't. Some did the pill and strip counting. Some didn't. So, some did some more monitoring for their MAT patients. But other than that, it really wasn't all that different from anything else. So there was a little bit of it's not really that big of a deal kind of response. That if you talk to those courts that don't allow it, that's kind of surprising, because the courts that don't allow it make it sound like it's such a big deal.
You done?
So we also wanted to focus a bit on the challenges for rural courts, where there's not as much MAT or any kind of treatment, and people have to drive great distances without a lot of transportation options. So we found in those courts there was heavier reliance on buprenorphine, let's say, than methadone, and ideally from the same outpatient program that other participants used. And that means if people get Medicare reimbursement, they don't have to go to one place, but again, they only permitted private doctors when there was no other option. And they all thought that with expanded availability of injectable naltrexone, that would be more logistically feasible, and so they were kind of hoping that that would happen.
The chat. Oh, great.
I'm going
Perfect
to
timing,
pause
Sally.
for questions again.
That's wonderful. You can hear me, right?
Yes?
Okay, good. There are several questions, just a few questions. I think going back a little bit, I know that one participant asked about when you were talking about the particular states that you're looking for to have test cases. And with that type of case, would you prefer to work with individual or attorneys, or would you work with the ACLU? That was the question.
Okay, we've actually been in contact with the ACLU about collaborating, so we don't really have a preference. I mean, I don't want to say what part of the country right now, but there is a part of the country where the ACLU is very interested in doing this with us, and the main issue is for us, the challenge is finding out what's really happening on the ground. So anyway, so the answer is, we're happy to work with any, at least talk to any attorneys who are, who have the expertise and the resources. And what's key is having the connections with the local defense bar. Because they're essential.
Right. Well, that makes a lot of sense, and that's the next question that came in was, what's the best way to get access to attorneys or judges to give educational presentations?
Well, I think that probably depends a lot on kind of where you are and who you know. If you're, and who you are. So, I mean, if you are a provider that takes referrals from a particular court, and there's some way you can, approach the court and say you'd like to talk about medication-assisted treatment, that might be one suggestion. Sometimes these discussions are kind of brokered by the local drug and alcohol agency can do it. Sometimes there are advocacy groups. So, I think it depends. The one thing I would say is that I think the tone of when one is approaching this to educate folks, I think it's best done when it's not in the heat of the moment. So because no one wants to be approached to be educated by someone who's angry. So how do you kind of sit down and let's talk? And I think that depends. So whoever has those particular questions, I guess can call me, but it really, again, it depends on who in your area is kind of working on these issues. And there are some state court systems that are also interested in doing judicial education. And so, and if you are, for example, a physician with expertise in MAT, and you can offer your services to train. I had a particular state that was interested in having me come out and train judges and other court personnel, and I said, but I'm a doctor, so it would be great if there was somebody who was an addiction doctor who could do the kind of what's MAT part of the training. And so if you have that expertise, or if you're working in a government agency, like a single state agency or a local drug and alcohol agency and have that expertise, I think you can reach out to your court system and those people who do the educating and say, I'd like to offer my services for this. So, or talk to the Center for Court Innovation. There's a lot of ways to go about it.
Thank you, Sally. Another question from one of our participants is, where is the line drawn between safe tapering with regard to effective and lethal dosage, which I think most providers try to move towards, the least restrictive, and err towards precaution of any legal trouble for being prescribers when studies show abuse across the continuum?
I am not sure I understood everything that was packed into that question.
I know. Let me read it again. Let's see.
Sure. Try one more time.
Okay. Where's the line drawn between safe tapering with regard to effective and lethal dosage, which I think most providers try to move towards, the least restrictive, and err towards precaution of any legal trouble for being prescribers when studies show abuse across the continuum? So the line drawn around safe tapering. Yeah.
Well, so that's not really a legal question, so I'm not qualified to answer that question. That's really a more of a clinical question. so I just don't have that expertise. I mean, all I can tell you is that when a judge says be off your Suboxone in a week, that is not that is not safe. But what the prescriber does, I think, raises very difficult is a difficult question. And I've talked to a number of MAP providers who are put in an awful position when they know their client may be incarcerated in a matter of days or weeks if they're not off their medication. But as they try and taper them down, the person starts feeling horrible and feeling like they might relapse, and what do they do? I mean, I think those are kind of questions that are really tough. I see that all the time.
Great. So I think the only other question that we had came from was about, will courts allow patients who are on take-homes?
Well, so the
I'm
courts
not sure in the context. Yeah.
The courts that we spoke to did not. I can only talk about the 10 that we spoke to in New York. I don't know what all courts do. But the ones that we spoke to did not allow take-homes because they wanted the daily monitoring.
Okay. Well, Sally, this has been really helpful. I think we've we've learned a lot today. I know I have, and the questions have been really helpful. I think that, and your answers have been very helpful. So I wanted everybody to know that you can certainly email Sally at sfriedman@lac.org, or you can call the Legal Action Center if you have additional questions. And just wanted to make sure that you did have a chance to download the file here on the left side. If you click on that and then click Upload File, it'll actually be this presentation that you see. It'll be in a PDF, so you can use it. And I also wanted
Patty,
to let
I just
everyone
want
know
to interrupt for a second.
Yes.
That the phone number that's on the screen is our DC office, and that's actually not the phone number you would call for me. You would call our New York office, which is 212-243-1313.
212
243-1313.
Okay, great.
Okay.
And yeah, so there's so many resources on the LAC website. It's lac.org, and it's just amazing. So I encourage everybody to take a look at that. And we're going to this webinar has been recorded, and it's going to be posted on the Faces and Voices of Recovery website under our webinars. So it should be there in about a week, and so you can share this with your colleagues in your whatever your offices and your peers. You're welcome to share it. So Sally, thank you so much for joining us today. This has been really helpful, and all of you that participated, thank you for your interest in this topic. And please, when we close today, there will be a feedback form that will pop up on your screen. So please take a minute to fill that out, and we'd love to hear your feedback. All right?
Thank you.
All right. Thank you, Sally.
Okay. Bye-bye.
Bye, everyone. Bye.